Good afternoon. It's really a pleasure for me to see professors, dignitaries, and beloved students. Those who are showing your interest to learn IPO, rather many areas of the IPO. The time we started our career in IPO, that was really a second word. Now it has become very popular. Every second I get the resonance of this word called IPO. It's good that India is moving forward, and our Prime Minister is also very much proactive for creating the IPO. Now, the most interesting area of the IPO, and rather very important, when I joined my career in a law firm, so I was exposed to this area because of my science background, that is patent. Patent deals with invention, very precisely. Well, I am not taking much of your time going through the much details of all those things, technicalities. Those things comes to our desk when we handle the clients, those who are intending to create intellectual property for themselves or for their families. So the patent, it deals with the invention. So whenever you invent something, you put your hard work, you confine yourself to the labs. So back of your mind is always playing, what is my benefit? Where do I stand? So once it becomes useful, so maybe the others will try to misuse it or exploit it. So the law has come forward. I'm not going much background of the law of the intellectual property, but the government has taken a decision to encourage you to go along with your invention and take the protection on it in the name of patent. It is a kind of exclusive right has been ensured by the government through some laws and for a certain period of time, and after that it enters into the public domain and that technology becomes generic. So this is in a nutshell the patents. So now patents covers that area I told you, that's the invention. So what is an invention? According to the definition of our Patent Act, that it should be a new product either or a new process, and it should have inventive step and more so industrial applications, because viability should be there for the industrial growth. So fitting to the subject matter is there. This is process either or product both. Both should be new, and I already repeated, I have already spoken that it should have the inventive step and it should have industrial application. But before taking the patent, because we being a patent attorney, what is my role? Because whenever anybody is coming and doing the invention or any research institutions, they are calling us, look, we have done some invention and now we want to go ahead with the patent. Now there are a few things you have to remember. First of all, like you have to think what is an invention? Like, whatever the known thing is there, suppose you're working in a particular field of science or technology, and then there definitely some other people, they have already done the work. And you are thinking in that way, look, this is a known thing, and there is a scope or there is a possibility of this improvement, or a product which is much more improved. Hence, that should be patented, covered by the right of monopoly, so that others cannot exploit it. So this is the thing, but whenever any invention is coming to us, we first try to understand, is there any patentability? So patentability is defined by our sections. We standard-wise, we see whether they are fulfilling those criteria, and then accordingly we tell them, we say, okay, it has a patentability, you can move forward. Now the second question comes, that is the search. That is very, very important for the patent. That is prior art. So prior art is what? Because which is already known to the public, which is already prevailing in the technology or the scientific area. So from that prior art, one should see what are the new developments has been covered by this invention. So that is a segregation point. So doing the search, the patent search is very, very important. First of all, to ensure yourself that whether similar kind of patent is already taken, covered by somebody else, or what are the new things you have developed, which is identifying, distinguishing your invention from the rest of the existing inventions. Now, according to the section 3, there are what are the not patentable, that I think Dr. Chakraborty has nicely mentioned. He is in a very senior position of the patent office area. So he has highlighted. These are the standard things. I am not going much details of that because the time is very short and you all are really hungry for lunch. So these are the things, process of medicines, the plants, animals. These are the things are not basically patentable. And then invention related to atomic energy, which is also not patentable. So now stages of filing the patent application, I am just very quickly touching upon it. Whenever somebody is coming for patent application, what we first ask that particular inventor, have you already completed the work or still you are thinking that you can do some more improvement? If he is sure that he is not requiring any further time to go for further invention or further development of the same invention, so then immediately we suggest him, you can complete your inventions, means write up your inventions in a very specific manner. That is the role of the attorneys, or you can do it also. There are a lot of specimens, a patent specification, it's called complete specification, that you can formulate in that way. If not, that if you still think that no, I want to improve, I am not sure about it, then what we suggest them, that immediately you file a provisional application with a provisional specification, so that your invention is not manipulated or snatched away by some other third person. So that is for your safety, you should immediately file a patent application through your provisional application, and within the 1 year's time, the span is 1 year, then you can file a complete specification along with your like other documents. So what is the difference between a provisional specification and complete specification? I'm just giving a very short idea. That Provisional specification will be covering the brief descriptions of your invention. And to understand the whole thing, you can give a write-up, short write-up. But the most important part of the patent specification is the claim. So claim area is not required to be filed along with your provisional specification. So once you are sure that yes, your invention is now complete and you should go for the protection, then immediately you can file your complete specification covering your claims. What is claims are basically the legal, the area where the legal protection subsists. Because rest of the area is very important to understand the specification or to understand the invention. But the claims are very, very important area where legal protection precipitates. So after filing them, there is a method that Dr. Chakraborty has already mentioned. Then the request for examinations and publications. So these are all standard procedures that is patent office is following. They are very, very helpful. They are very knowledgeable to expedite the things also. And like I am a patent attorney, we interact with them very frequently, and we get a lot of cooperation from them. Now, then whenever you file your patent application, then it passes through the examination, the process of examination. So what is the examination? Because the patent examiner, who is the expert in that particular field, and he will be examining your invention, and he will point out if there is any latches or any shortfall which you should cover by giving the reply to those examinations, objections to the examination. And if you complete it, then definitely in grant of patent is there. And one more thing is there, that is a patent opposition. Like if any other persons whose invention is conflicting with going to be granted patent application, so somebody can come for opposition also. This is the normal procedure for the patent filing and patent, just like obtaining the patent in India. Now, what are the documents required? Is a form, then proof of rights of apply, provisional or complete statement of what if there is a foreign applicant. All those things are very standard thing. Then abstract is there, then drawings are there. If your invention is supported by drawings, you should mention the drawings also. Those are the things. Then I have already mentioned this is a provisional application, the specification. It describes the nature of the invention, contains the description, essential features of the invention only. No need to include the claims. Now, complete specification has a very standard form. So very, very specific, otherwise a lot of the objections will come during the examination procedures. So one should be very careful about all those things. One is the title of the invention, then field and background of the invention, then usefulness of the invention, then prior art, you have to narrate the prior art. From that area where your invention lies, that demarcation you should mention also, so that the examiner can understand where your invention begins. So then object of the invention, summary of the present inventions is supported. All those things are there. And especially the claims. The most important area is the claims. And examiner will check all the formalities, that is examination procedure I have already narrated earlier. Then publication. Once it is followed through, then a publication is there. Like application is accepted for a certain period of time, and then after the 18 months, it is published in the official journal, also 19 months. So these are a very, very important area. Request for examination is there. If you request for examination, then examination process will begin, and examiners will take observation on the filed application. But what is the examination? The application is sent to the examiner within a month from the date of request of examinations, and examiner takes. This is a standard procedure. It's nothing to worry about. Then we call this a fast examination. This is a FER. So that's why this even my topic is headed by this term called as a FER. That is a FER. That is a fast examination report. And if there are objections from the patent office, so you have to comply with those objections or the requirements, and after that it will pass through for that registration. And then there is a reply from the applicant is coming also. Now the opposition. So when the opposition, there are opposition two stages. One is the pre-grant opposition. Then after the publication, an opposition can be filed within a period of the 6 months. This is the thing. And there is another opposition, examination of pre-grant opposition is there. So then whenever you file an opposition, there is a procedure also that at the pre-grant stage, then that is pre-grant opposition. After examining the opposition, submission can be made. Whenever you file an opposition, you have to remember that if you oppose somebody's invention, you have to give the legal justification behind it. You have to give the citation challenging his claim for novelty or newness, his inventive states. Those are the parameters you have to keep on your mind. And then the grant of patent is there. And if like your opposition is, there is another stage where a patent office can refuse your patent, then you can also request for some appeal to publication of the grant. After the grant of the patent, the controller shall publish the fact of the patent has been granted. The publication is there so that it is within the public knowledge. Once it is public knowledge, then again post-grant opposition you can come along also. That is another stage of kind of opposition, like what we do also like in other areas of the intellectual property. So in a notice of, whenever you file, you intend to oppose somebody's invention or somebody's patent, more or less. So you have to come with a notice of opposition. Like that is a statement of your facts and your grounds of opposing that particular patent. Then the applicant will also file the counter statement. This is his reply also. Then definitely after that, if additional evidence are required, then definitely the controller will grant that kind of sanction that you can file that evidence. And then ultimately that is the stage of hearing, and the reply statement and evidence by the patent is there, and filing the reply evidence by the opponent also. That is a different time limit is there. You have to follow those time limits. It's nothing to concentrate much on these things. These are all procedural things. So that is the hearing. Hearing is the most important thing because you can plead your case and other side can plead other case, also his case. And on the merit of that particular hearing or the adjudication, the matter will be decided as to whether patent will be granted or patent will be refused. So what is that if the rights, the patent is covering, that if the patent is for a product, there are two kinds of areas what patent encompasses. One is your product. Whenever a product is covered by patent, so then what is happening? That is, situation is that right to prevent others from making or using or offering for sale or selling and importing the patented product, because there is an embargo, the legal embargo on that particular product. Similarly, whenever the patent is covering that a process, then that process is very unique. It is somebody's monopoly, one particular legal person's monopoly, and that process cannot be followed to develop any other product or can be used for any other scientific development, because that would be that tantamount to the infringement of the patent right. So this is the two different interesting areas. I mean, it's like the product or the process. So these are the two things which is covered by this the present Patent Act. Previously, there was no the monopoly right as far as the patent is concerned on the process area. We used to get only the product. So if you have any question, you can ask me in respect of the patent filing or the prosecution. I'll be happy to answer your questions.
Thank you.
I can take the call.
Thank you very much. Thank you very much. There are a lot of questions which are already waiting. So I would request the audience to spare some 10-15 minutes to the speakers. I know we've gone beyond lunchtime. But I will start with our first speaker, Dr. Amity. He has a whole lot of questions and he will answer them. Those who have sent that question, you can raise your hand and ask, if you're not clarified, you can ask him again.
So the first question that I'm thinking is from Arjun Choudhury. Arjun, shall I read the question? Have asked me that method of the issue is method of treatment of human beings, and you are saying that pharmaceutical invention, although chemical or biological, are used for human beings, so treatment of animals, and pharma inventions are patented. Isn't that contradictory? No, it's not exactly contradictory. You cannot say that this is contradictory, because when you are giving well, I am not the person to defend the policymakers. I do not hold the brief anymore. But as far as my understanding goes, that when you grant the inventions on the method of treatment, that basically creates a right which can even infringe the right of a doctor, which you cannot do. Say, if a doctor wants to if a doctor is not allowed to practice freely, then it is, at the end of the day, it will create a lot of detriment to the public society. Am I correct? This gentleman has not given his name. First question is, I have come across that all countries are trying to move from product patent to process patent. No, it's not coming. After the trade settlement, all the countries are moving from process.
Would you like to identify yourself? Whose question this is? What's your name?
Well, Bhavish, the thing is that now both the process and the product patents are to be given as per the mandate of the trade settlement. The countries which are still allowed not to grant the product patents are the least developed countries, for which the time given is up to 2030. Okay. Your next question is, the trademark is renewable and it has been mentioned in the slide, but sir, can patent or design be renewed in any circumstance? Yes, patents and designs are renewable things. They're to be renewed. If you don't renew them, design is initially granted for 10 years, so then you have to renew it for another term of 5 years. And for patent, you have to, after the expiry of second year, from the third year onwards, you have to start paying the annuity, failing which your patent will expire. Your last question is, what is your, what you further about compulsory license? I couldn't.
What is the question? Can you?
Yeah, yes. Yes. What exactly your question is? Yes, you are very correct. Compulsory license is a license which is given under compulsion. That is, there are certain conditions which I believe that is not within the jurisdiction of this lecture. Anyway, I would like to say that if you make abuse of your invention, if your invention is sold and not at a reasonably affordable price, if it is not available in the market in a sufficient quantity, if it is not worked in India, then in that case, and there are some other grounds, in case of national emergency, in case of extreme emergency, in case of public non-commercial use, the government, the patent office can grant compulsory license to a third party which failed to obtain the permission from the original inventor or the original patentee to this third party to manufacture that particular substance to mitigate that particular situation. Once the situation ends, the compulsory license may not exist. Now your question is that why most international pharmaceutical companies criticize Indian compulsory license policy? Well, after granting the first compulsory license in Narco case, it was next ever case. The doses regimen of 6 to 9 months used to cost around 35 lakhs rupees. 35 lakhs, and that it was not a life-saving drug. It was life-extending drug. The controller of patents granted the compulsory license. It went to High Court. It went first to IPAB and thereafter to High Court. Mumbai High Court upheld the decision of the controller with a very minor modification. The royalty was modified from 6% to 7%. And thereafter it went to Supreme Court. Supreme Court summarily rejected the petition of the aggrieved party. Now, after granting this compulsory license, yes, certainly we were subjected to huge discredit campaign, but it doesn't matter to us. Because the compulsory licensing provision which are engrafted in Indian law is as per the TRIPS agreement. It is in full compatibility with the TRIPS agreement, number one issue. Number two, a patent in India is granted as per the policy decided by our parliament, as per the requirement of the Indian people. Okay? Someone has asked me, sir, kindly highlight the stance that India has taken on CRI, some CRISPR-Cas9 process which has been held as a revolutionary genetic technology. Well,
Which question is this? Yes, please. What's your name?
Is there any patent issue in it? My question is that is there any patent issue? Then I will not. The law governing the use of service marks in India. I think that I have already covered this thing under the trademark, or Biswajit may like to reply to that. Yeah. If pruning of human beings is not permissible under patent law, will this, if making of human beings is not permissible under patent law, will this apply to cloning of human beings you want to be? You want to be cloning of human beings? No, will not be patentable. When we file a patent application, what is the line, what is the time taken for examination for patent to be accepted? It has already been explained by Dr. Sarkar. So kindly highlight the controversy regarding Section 3D of the Patents Act 1970 as amended in 2005. So, is there any necessity to highlight the controversy regarding surrounding section 3? It's again some section. Look, TRIPS agreement has some inbuilt flexibilities, and that has been admitted by the ministerial declaration in Doha. Doha ministerial declaration has categorically stated that TRIPS agreement has many flexibilities which need not only many flexibilities, exceptions are also inbuilt in the TRIPS agreement. India simply taken the advantage of that flexibility and has given something in section 3D by which a mere variation of an already existing patent is not, or already existing technology is not a subject matter of patent. But, hello, may I have your attention please? Please. So, but yes, it was again a subject matter of a huge discredit campaign. But we can see that what section 3D confers through the patents law is basically nothing but try to obvious issue. It's quite a complicated matter and I don't want to prolong the discussion right now. Okay, thank you very much for asking this interesting question.
Hello.
Hello. Yes. Hello. Yes. The first question is that patents are mentioned. It is territorial grant. How Indian students approach foreign innovators
Whose question
or
is
researchers for collaboration and ideations?
What's your name?
Prabhat Das. Suprabhat Das. Suprabhat. Your question is that you want ideation and a different thing, collaboration with the foreign inventors. Actually, you cannot make collaboration with inventors. But one thing you can make, inventors will not disclose anything to you until and unless you are having a very high reputation with the your credentials. The thing is that whatever you wanted to ask me, that is whatever I guess that you wanted to ask, that how you file a foreign patent. That is your question. How you can file a foreign patent? One thing is that one question, one answer is very simple. If you have money in your pocket, you can file a foreign patent. There is no problem. It may cost, I don't know, a single patent filing may cost 10 lakh to 20 lakh rupees. And for maintenance and all these things, maybe it come around a crore. Actually, it is a useless option. The second option is that I will suggest you are a student, that you go through many, few websites are there. They are giving some problems in the websites like 9 Sigma and some others are also there. But 9 Sigma is good. You go through their problems, whatever they are suggesting there, they are asking the solutions from you in different areas. So, if you can just crack it, basically, if you can give a good solution that they will accept it, they will find the patent themselves. That is the way you can have that these agents, basically intermediaries, to file international patents and to continue that thing. The second question is also from you. That is, the second is can patents be granted for projects that have environmental impacts, but is improvisations and advancement in existing software idea from technical perspective. Actually, this question is not very clear. This question encompasses various things, the environmental impact, software, ideations and all these things. So, this is the question. You have to pinpoint the question, that whatever you have in your idea, but a very specific idea is to be patented. A thorough literature is not patented. The third question is that somebody else has asked how to convert your idea into reality. That I have discussed a little bit there, but that needs a lot of discussions, a single, so it will take time. Okay, thank you very much.
Dr. Amitabh wants to make a
See, regarding your first question, that is how you have to file the patent in other patent offices, as his our learned professor has correctly pointed out, it's extremely cost intensive. But for the purpose of getting assistance, you can perhaps talk to the nodal officers of the universities, and they will be of great help to you. Thank you very much.
Okay, now we have the final questions, and I have three of them. I am continuing with these questions because then the audience will feel more connected to what they have heard. I'm sorry to the audience that we've taken a little more time than we should have, but I think there are only one or two of them, so we'll request Mr. Biswajit Sarkar to. If you don't have a name, please read the question, then they will give a name.
There is a question, like as you mentioned that patent has a territorial nature, but in the era of de-territorialization and knowledge era, where sharing of ideas is very much in prevalence and global menace like poverty, certain disease falling around, the patent or medicines and such entities is both the unity that our human rights that we speak about. And also as a lawyer, don't you think that when patents relating to medicine is possible, there could be a bar on the humanitarian ground, especially when...
Whose question is this? What's your name? You've written in one full page of question. Why will you come there so that everybody can hear? We have a mic for it? I'll just come there quickly because we have just one more question after this. Just give us the crux of your question.
Good afternoon, sir. So the question is basically coming from a layman's perspective, like all of us sitting here. We want to know that we are standing in an era of deterritorialization, and also when Sir has also mentioned that we are sharing ideas, right? And there are a lot of countries which are underdeveloped. So the problem with patenting is only that the time span which is involved. It's a very tedious process. So when it comes to the other perspectives are okay, right? You know, when it's good and all, it's fine. But when it comes to medicines and something which is of relevance when it comes to health sector, there are countries like Ghana, there are countries, North American countries are very, very poorly stated right now. African countries are there. India is also a developing country. Don't you think that patenting, when it comes to these criteria, medicines, and also, you know, like as of now, dengue in Calcutta is very high. So let's say the medicines which needs to be addressed in a very short span of time, patenting is restricting that. And to that, answering the question which I have is like humanitarian grounds. We have human rights law, right? So human rights law basically treats the perspectives about health and all these things. So as lawyers, when we grow up, when we grow in the horizon of tomorrow, don't we find a conflict between intellectual property rights and human rights law? So that is my question.
Okay, I followed your question. It's a kind of your emotional involvement with society. And undoubtedly, yes, the patent is a lengthy process because it has a lot of legal orders which has to be clarified by the statutory body that's talking about this. And after that, if there is any controversy, it reaches a court. As you are a law student, probably you are a law student, I can make out from your writing. So you should be very careful that, well, the court doesn't value the emotional things, although these human rights and other welfare situations are there, but still the law has its own course. So you have to always keep on your mind. And besides, sure.
Basically, it's a very interesting question because I am also very much interested in studying the cross-section of the human rights and the IPs. If you just see the Universal Human Rights Declaration, Article 27, it acknowledges the right of the intellectual property. But afterwards, these several human rights, omission on human rights and intellectual property was a commission which was set up under the UNHCR. So actually what they have prescribed is that there must be a balance between the rights and obligations. So every patent office or every country has the right to craft its own law according to the suitability of its own requirements. Okay, and while drafting this patent law, we have taken care of the public health policy issues. We have so many provisions like compulsory licensing, like the government issues, which protects the public health to a great extent. Government has taken all due care. Our parliament has taken all due care. And Section 3D is also one of such flexibilities, the benefit of which we have taken. Thank you.
Thank you. You can send him an email if you want more. Do that, please. One or two more questions are there.
There is a question Nivedita Basu.
Nivedita Basu.
Okay, you have asked the questions on service mark. So, is a law growing the use of the service mark? Yes, the service mark was not here in our old Act, 1950 Act, Republic, the service mark. Now, service mark is there basically. India is very strong in providing services, and we are very good in different kind of services. So, as far as the service mark is concerned, is covering that kind of various services. But previously, there are 3 classes for services. Now it has extended to more classes up to class 45. So previously it was up to class 43. So those services are very much important. Now still we feel, as per the nice classification, like some of the services are very, crammed in one particular services. I myself have seen people cases where services are not categorically mentioned in the nice classification. Whether I communicated the wife also, they asked my suggestions also. Maybe sooner or later, because the services are going in a different time.
Give us a few more minutes. Please don't go away. Please give us a few more minutes. This is for the interest of all of you.
So that's
outside.
What is the time limit? Somebody has questioned that is what is the time limit for the examination. So, the examination, because if you can make the request for examination, it can be early examination also.
Thank you very much. Thank you to the panel. I think I'm very glad. Is there a question? I'm very glad that it has actually raised so many questions, which means all of you have actually very effectively tried to grasp what the speakers have said. And that is essentially the crux of a workshop. If you have a workshop, it is important that the audience is just not an audience. And you have been interacting with the speakers. I'm so glad the speakers have done such a wonderful job. And you are free to send them emails and ask them more questions hereafter. There is, I think, one small question. Patents are territorial and on the same hand, they cannot be granted to it. Who is this questioner, please? What is your change? You already did. Shall we skip this question now? Okay. So thank you very much for being so attentive, all of you.
Thank you.
After they finish up, go for lunch. Don't go in between.
Thank you so much, sir. Thank you all of you for we gathered so much of knowledge today. Now I would request Dr. Biswajit Sarkar and Dr. Manik Chakrabarty to be on the dais to felicitate our speakers.
one more announcement on our forms that if you have any question relating to the patents or the intellectual property, you do visit our site www.biswajitsarkar.com. You can write it down and then you can forward those questions to us and we'll be answering. We'll be happy to answer.
So just one small thing.
Here to give their lecture. Thank you, sir. And I also thank the audience present here. Thank you very much. And also, I thank the chairperson of this interaction. Thank you very much.
On the behalf of the organizing committee, I request all the students who have their coupons, please go outside for lunch. And please, after lunch, please gather here within next 25 minutes. We'll start